right, here we go. MPEP 1300. This chapter is titled Allowance and Issue. So it's basically all we're going to talk about. So last things first. The last thing that happens in an application is the issue fee. So once a notice of allowance is sent, that starts a 3-month clock for submitting the issue fee. The 3-month clock for submitting the issue fee is started at that point. So now this is a non-extendable timeline, but it can be paid late under 1.137 with a surcharge. And so rule 1.137 is the rule for abandonment. And so basically everything for abandonment goes through this rule. And so if it is submitted late in that case, so if an issue fee is submitted beyond that, the application is considered abandoned. And so in that case, a petition under 1.137 with a surcharge is required. So then formal drawings are also due at this time, but those can never be submitted late. So now a notice of allowability, an examiner can submit reasons for allowance, and these are sent with a notice of allowability. And so reasonings why the examiner might put these forth are in MPEP 1300, but basically it's just if the examiner is kind of wanting to defend their position as far as why claims were allowed, what kind of evidence was used, and all of that might be used down the line in a re-examination or a reissue. So now the applicant can choose to respond. So if they are responding, then that's going to go into the case. So that's not going to be something that affects anything, of course, at this point, because the case has been allowed, but maybe the applicant down the line would want to reissue, and so they want to make it clear that they were against the prior art that was used, or maybe they were just trying to put forth that they did X, Y, and Z, and the examiner did or did not listen. So just basically putting it in better form for them for down the road. And so, yeah, so if they do not respond, then the file wrapper estoppel can be brought forth in reissue re-examination cases. So basically, well, you didn't do anything then, so you can't add anything to the file wrapper at this point. So an advantage to responding to the comments would be to add additional protests in the case of challenges down the line. So now, but the lack of applicant answering does not indicate acquiescence of an examiner's answer. So it doesn't mean that the examiner's answer is accepted just because the applicant did not respond. So now for deference of an issuance, that can be accepted after the issue fee is paid. So that petition is put forth after the notice of allowance is sent. So you put forth that petition and the fee, and then it's only accepted after the issue fee is paid. And then as far as how long, it can be only extended more than 1 month. And then requesting applications to be issued at the same time is usually granted there. When it comes to withdrawal from issue, CFR 1.313 is a good one to remember, because that can come up in a lot of different things, maybe where an IDS needs to be reviewed after an issue fee has been paid. But basically, withdrawal from issue is always about after an issue fee has been paid. So this is saying, for stepping back for a moment, prior to paying the issue fee, withdrawal can just be done with a petition and fee or continuing application. So you don't have to go through the petition of 1.313. But after the issue fee has been paid, the application can be withdrawn by the PTO if there was some mistake from the PTO, if there was some violation of a duty to disclose, unpatentability of claims, or an interference. After an issue fee has been paid, an application can be withdrawn with the petition under 313 and a fee by the applicant. And so those reasonings can be abandonment to consider the IDS and continuation of application, or an RCE. So when we're saying abandonment, we're saying the filing of the continuation, and then the parent is abandoned, of course, if you don't pay the issue fee, or an RCE can be filed in that case. That can be due to unpatentability of a claim, so wanting to protect oneself in the future from further prosecution costs by withdrawing from issue so you can cancel the claim. So now when it comes to patent term and term extension, these are not actually in MPEP 1300, except for just briefly mentioned in a couple areas. This is more MPEP 2700. So if you're needing to look something up, that's where I would go first. But basically the major rules here are going to be the magic date. So first off, 6/8/95 to 5/29/2000, patents could have 20 years from filing, extended for their term, extended up to 5 years for delays. A design term, it was 14 years from issue until 2015, and then it became 15 years from issue, so big change. For utility and plant before that magic date, it was 17 from issue or 20 from filing. Now from 2000, it is now just 20 years from filing. For PCT, that's going to be after 6/8/95 for the national phase is 20 years from PCT filing. So it doesn't say for effective filing date, so that's kind of interesting. So now remember that provisional and foreign do not count in patent term. However, domestic does. So now there's a rule for extensions that is helpful to kind of remember or to kind of have fuzzy in the back of your mind is the 14444 rule of extensions. So that is if it's greater than 14 months from filing or national stage entry. So from that point to the notice of allowance, first office action, written restriction, or examiner request for information. If whatever time greater than 4 months to reply to an amendment or appeal, running from the time the brief and fee are received. Whatever time is greater than 4 months to act after a decision by board or a CAFCA. And then whatever time greater than 4 months to print the patent once an issue fee has been paid and all other issues satisfied. So this 14444, this provides a basis for which a patent term can be extended, and so this is one of the bases that it can be added up by. So then as far as how the extensions can be obtained, there's the 14444. If the overall pendency is greater than 3 years, and then there's certain applications which when they're put forth, they mess up the 3 years. That's going to be an RCE, a secrecy order, interference, and unsuccessful appellate review. And if the applicant requested delays, so suspension and then so suspension of action, those sort of things. So now delays due to pendency, secrecy, and appeals, there can be extensions. So a little bit counterintuitive, they can and they can't have extensions, but for appeals, those ones, pretty much any of these will only have extensions if there's a complete reversal and a total allowance of at least one claim. So then applicant delays do count against extensions, but it will never go in the negative direction. And it's all based on the receipt date at the PTO. If there's any discrepancy that a practitioner may find in the PTO calculation of the patent term, then it must be filed within an extendable 2 months. And so that the description of what the patent term will be set forth at the time that the issue fee is paid. And so once you receive what that issue fee is going to be, then making sure that the exact expiration date of the application is correct based on your estimations. So now provisional rights, I am honestly not quite sure where to find this in the MPEP. I've just seen it referenced in different study guides, but I decided to go over it. So after an application is published, patent upon issuance is eligible for royalty for that time period in between. So maybe it was published at 18 months and then was issued after 20 months. For those 2 months in between, a patent owner is eligible for a royalty if the owner of the patent provided a notice, like a very clear notice of what was being infringed upon to whoever was infringing. And the patent claims are basically identical to the claims in the published application. So when it's based on international publication, and then that just requires that the applications published are filed at the USPTO, either a copy of the publication or an English translation copy. And that is it. Hope that was helpful. Thank you.